Hello, this is me, Shirish12032338, and I'm here to give my suggestion and advices regarding the case that I have chosen. And I would like to start with the introduction of different business structures. Well, I would like to start with sole proprietorship. The simplest way of doing business is to trade on your account with no special organizing structure called a sole trader. Often people want to go into business with someone else, either to share the work and or the capital input and expenses, or simply to share the worry. The simplest way to do this is through a partnership, often called a firm. A partnership is a business structure owned by two or more persons who agree to carry on business together for a profit but decide not to incorporate or form a limited liability company. There are three types of partnerships, and they are general, limited, and limited liability partnerships. In a general partnership, profit, losses, and managerial responsibilities are shared equally among the partners. Each partner has unlimited personal liability, which means that any or all of each partner's personal assets can be taken in a lawsuit or to settle a debt. Like a sole proprietorship, a general partnership is relatively easy to set up and maintain, and no paperwork is usually required to create it. Once you and at least one other person get together and sell a product or service for a company, a general partnership has begun. It's that simple. So, partnership status confers solely and automatically from the business activities of you and your partner. And partnership law automatically applies to your business and to you as partner. You will need a DBA doing business as if you want to use a trade name. As with most things, it is usually a good idea to have things in writing, so you should invest the time needed to draft a written partnership agreement. Each partner is personally liable for the debts and obligations of the business. In other words, there is absolutely no protection for you should you get into a legal situation. So keep that in mind as you from your business together. If you don't, the partnership laws of your state will govern how your partnership will operate. Your partnership agreement should include how the business will be financed, how will do what work, who will do what work, what happens if a partner dies or becomes disabled, and what happens if a partner wants to leave. The IRS considers a general partnership a pass-through entity, which means that, like a sole proprietorship, profits and losses flow through to the partner's individual income tax returns. All the partners will share in the profits and losses of the business, as well as be jointly and severally be liable for all of its debts, liabilities, and obligations. Each general partner has equal responsibility and authority to run the business and to bind it. What this means is that any one partner can commit the partnership by entering into an agreement on behalf of the partnership, and all the remaining partners will be personally liable, regardless of whether they authorized the agreement or even knew of its existence. Because each partner has unlimited personal liability, a general partnership is the most dangerous type of entity to form. Not only can you be liable for any agreement your partner enters into, you can also be held liable for any partner's negligence. In addition, each partner is personally liable for all of the partnership's obligations. For example, if you are one of 10 partners, you are not responsible for 10% of the partnership obligation. You are responsible for 100%. If the other partners are unable to pay their respective shares, you will be responsible for the entire amount. The advantages: first, general partners are relatively easy to establish and are strictly regulated than corporation or limited liability company. Second, with more than one owner, the ability to raise capital is enhanced because you have more resources to draw upon, and the capacity to draw money is usually greater. Third, a partnership benefits from the combined abilities of a group of persons who has complementary skills. One person may be good at marketing while another may be good at operations. There is a wider pool of knowledge, skills, and contacts to draw upon. And the disadvantages, the first and the foremost, the main disadvantage is the fact that partners have unlimited personal liability, and for all business debts, obligations, and liabilities. If the business is sued and judgment is obtained, all the partners could lose their personal assets to satisfy their judgment, and if their business goes bankrupt, all the partners will have to clear that debt, even if it means selling their personal assets. Second, profits must be shared with others, and you will have to come to an agreement on how you will value each other's time and skills, which in itself can be a real challenge. Finally, the partnership usually have an unlimited life. It can end upon the withdrawal or death of any partner. So I believe that partnership would be the right choice for my case, and my case has stated that John and Stephen Green has been recently inherited 3 million from their father's estate. So I believe that considering all the different business structures, this is the most suitable one, because establishing the partnership is quite cheap. It's easy. It's a easy process without much complications, and both the brothers want to invest $3 million in this real estate business. And mostly through my research, I've seen that most of the real estate firms actually are working based on sole proprietorship model or on partnership model. So there are quite few companies that are working with the public company limited model, but basically I would like to focus more on partnership model based on the fund that the brothers have, and based on the level of expertise they have. I would like to suggest John and Stephen Green to go for partnership. Thank you and have a good day.